Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello and welcome to Absolute Trust Talk. I'm Kirsten Howe, the managing attorney at Absolute Trust Counsel, and I have with me here today one of our associates, Ariana Flynn. You've all seen her many times before. Ariana just got back from a weekend in Las Vegas. Was not what you normally think of as a weekend in Las Vegas. Tell us a little bit about what you were doing down there.
Yeah, absolutely. Yeah, not your typical Vegas trip. I was actually there for a basketball tournament. I coach a traveling team sponsored by Nike, and we had one of our tournaments in Vegas, and we're actually heading over to Chicago this weekend. So I actually leave later today for my flight, and Chicago, this is the final tournament, kind of the end of the season tournament. So yeah, very exciting.
That's great. And it went well. You won some games this weekend.
We did. We won some games, and then we also learned from some games too. That's how we phrase it.
That's the way you do it.
Absolutely.
Either you won or it was a learning opportunity. That's
definitely
good. Positive coaching attitude. Okay, so but you all are not here to talk about basketball or even Las Vegas. We're here today. We're going to talk about advanced healthcare and end-of-life planning. And I was inspired to do this episode because in the last maybe 2 or 3 weeks, I've had a number of conversations very similar with different clients on this topic. And we got into a lot of really deep, kind of heavy stuff. And it reminded me of how often I have these kinds of conversations with clients and how much misunderstanding or half understanding there is out there. And my vision is that we're going to bring it all together in one place, everything. Don't worry, it's not going to be one episode. The plan is to cut it into 3 short episodes because we know nobody wants to listen for 45 minutes to a couple of attorneys talking. So we're going to cut it into 3 logically separated episodes. But my goal is to kind of cover the whole territory on end-of-life planning, healthcare planning. We're going to cover assisted suicide. We're going to cover euthanasia, all of it. All right. So today, though, we're just going to cover the legal documents that should be part of every estate plan. As part of what we do as estate planners. We're just going to talk about those 2 documents. So Ariana, let's have you talk about the first one.
Yeah, absolutely. As you just mentioned, one of the big 4 documents of your estate plan is the Healthcare Directive. We are California-specific, so this is a California Advanced Healthcare Directive. And that is a document that does one of several things, but the main kind of thing it does is helps you appoint a person to make decisions for you in a medical sense if you're not able to make those decisions yourself. And the Healthcare Directive provides a roadmap of your preferences and decisions on these, specific treatments, like pain relief, artificial ventilation, hydration, things like that, and anything else that you may want to kind of add into the Healthcare Directive too. For example, blood transfusions or some other sort of niche and specific healthcare decisions that you would like or would not like. The Healthcare Directive also can touch on, the expression of end-of-life decisions as well. Kind of that myth of, the Healthcare Directive is just who gets to pull the plug, but it's really, beyond just that one decision. It encompasses so much more.
Right. And so the main, I think, takeaway about the Healthcare Directive, well, there might be a couple, but as you said, the point of it, the legal aspect of it is that you are naming someone who will make decisions for you. They have legal authority to do that. That is the legal function of that document. In addition, you can throw in your wishes. This is what I would like. This is what I want my healthcare agent to know. But those are wishes. They're not legally binding. What's legally binding is that person has the authority to make those decisions. And the second thing I would say, and this isn't as a result of what you said, but this is something that everybody needs to have, everybody 18 and over. Once you turn 18, your parents are no longer legally, you're not their responsibility anymore, and they don't really have any legal rights over you or your decision making. So everybody 18 and over needs one of these, whether you have a lot of money or no money. You might not need a will, but you do need this.
Mm-hmm.
Okay, let's talk about the other legal document, which is something that we do in our practice. It's not one of the big four, but we do it because we think it's important.
Yeah. And I'm sorry, I'm going to go back to the healthcare directive. Just one more comment on it too. It's not a permanent document. So once somebody starts acting as agent, if you regain capacity because it's a temporary incapacity, you are able to then step in and make those decisions for yourself. I just want to make that clear as well. It's not you hand it over permanently.
Right. No, good point. Yeah. And it's also revocable. You can change it anytime you want to. If you've picked somebody and then 5 years later you think, no, they're not really a good choice, you can name somebody else. It's always changeable.
Absolutely. Yeah, the second kind of ties into the healthcare directive kind of as an ancillary, document, I would say, is the HIPAA. I'm glad I wrote what the HIPAA stands for because I cannot memorize it, but it's the Health Insurance Portability and Accountability Act, I believe of 1996, I think it was.
Oh, good. Yeah.
And that's a federal law. So this is beyond just California. That's a federal law that keeps medical private information private. What that means in simple terms is that a doctor can't release medical information about you to anybody automatically. You need one of these documents for them to authorize that release of information. Again, even if you are a parent or a boyfriend, a girlfriend, child, you do need that written release for the doctors or medical staff to be able to discuss openly the private medical information.
Right. And that's a federal act. California has its own act. It's called the Confidentiality of Medical Information Act. California always has to do something extra in addition. Right. And the idea is the same. Your private medical information is private until you say it's not, until you give permission. The thing that California layers on top that's relevant for us is that the HIPAA release, if you're going to be giving somebody the ability to release your private medical information, it has to be in a separate document all by itself. It can't be buried inside your healthcare directive. Or we see this, sometimes we see them in trusts even. There's like a paragraph with a HIPAA release. In California, that's not valid. It has to be a separate document. And it also has to be in a 14-point font, which is not the typical font that we use for documents. We're usually working in 12-point font. So,
Not the default. The default in Word is not 14.
Right. And when you see one, you'll see it noticeably is different. The font is larger.
Yeah.
And that's because of California law. Okay. So those are the two legal documents that we prepare that we think should be a part of everyone's estate plan. The Advanced Healthcare Directive, that is absolute must for everybody. Ariana, is there anything else you want to say about those two legal documents?
No, I think we covered both of them pretty well. And I just know that clients do often have personal wishes that they do want to put into their healthcare directive. And that's a perfect opportunity to do so to help guide their agent. So it is a necessary and really important document.
Yeah. Part of our homework for our estate planning clients is a worksheet just so they can sit down and sort of think about what they want to say in their healthcare directive. And I think just going through that exercise is important. Whether you put things into your healthcare directive in writing or not, just actually thinking through it is a good idea. And even better, talk to your family, have a conversation. Okay, so as I said, we're going to pick this up in a second episode. We're going to talk about some more documents, not the legal documents. We're going to be talking next episode about medical documents. So we hope you learned something today, and we will connect with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.